very good afternoon, your lordships and ladyships. The council has the humble pleasure of appearing before the Honorable High Court of Munan in the case of Bistro Pharmaceuticals versus BZ Mate University. Being the appellant, the council is representing BZ Mate University in this forum. If your lordships and ladyships are well versed with the facts of the case, the council would like to proceed with the first argument the council has. Before this court, the council will be submitting arguments on two grounds. That is, whether a QRTMA injunction can be granted, and secondly, if a pre-grant opposition has been filed, whether a post-grant can be filed on similar grounds or not. Coming down to the first issue with the permission of the Honorable Bench. On whether a QRTMA injunction can be granted, the council submits that yes, it can be granted. Now, to understand what is a QRTMA injunction, the council would kindly like the lordships to refer to section 108(1) of the Indian Patents Act that holds good in Varanasi as well. Your lordships, what we need to understand prima facie is that the Indian Patents Act does not distinguish between the types of injunction as the CPC does, your lordships. In this case, injunction has been defined under section 108 clause 1, which can be granted either as an interim injunction or a permanent injunction. Hence, since the moot question here is what a QRTMA injunction, whether it can be granted, the council has relied on the case of Mars Incorporated versus Krishna Mukherjee. If your lordships were to refer to page 15 of the plaintiff memorial, the same has been adopted by the Honorable Delhi High Court. In this case, the court has said that a QRTMA suit is an action that is apprehended, and is the essence of a QRTMA injunction is what needs to be observed. And if the court might kindly take...
Isn't the Mars judgment a trademark case?
Yes, but...
Isn't the nature of right different?
Though the council concurs that the nature of right is different, but the council has simply relied on this case to bring in an inference as to what a QRTMA injunction is. The remedy is not the end that the council seeks through the present case. If the council may forward with the pleasure of the bench, the council may try to substantiate the same. The council would like to point out that what is the nature of a QRTMA injunction. The Delhi High Court in this case observed the Osborne Concise Law Dictionary's definition of the same, wherein a QRTMA injunction can be granted at a threat of infringement. And in this case, the council will try to substantiate through his arguments how the threat of infringement remains. Further, to clarify on this issue, the council would request the bench to observe something that was established in the Matrix Laboratories versus F. Hoffman-LaRoche decision. The court went on to observe that the nature of a QRTMA injunction is prohibitive in nature. The same has been stated in page 15, wherein the court says that something which is evil should be nipped in the bud. What is the onus on a country?
Doesn't Roche versus Cipla say that in a patent infringement action, you need to be able to test the two products? And so, if the injunction you are seeking is QRTMA, so there cannot be any testing because the defendant hasn't launched the product, isn't it? So, how do you say that in a patent action, you can maintain a QRTMA injunction? How do you know what is the product which the other side is going to launch?
To answer that question of law, the council will try to clarify the same through the facts that have been stated in the moot problem. Herein the case is that a pre-grant opposition as well as a post-grant has been dismissed in favor of the plaintiff. So there is a balance of convenience that stays with the plaintiff all throughout. Furthermore, if your lordships would refer to paragraph 9 of the moot proposition, therein there has been an RTI application, if the court might take it into record. RTI application that was filed and which showed that there was a threat of infringement. In this case, the parties that the council represents had filed an RTI application which showed that they had applied before the Federal Drug Authority of Pandora for licensing the same product. The product that we are talking about here is the antagonist API that is supposed to release pain. And the same will be contended by the co-counsel before the IPAB. Those trying to substantiate the same, what the threat of infringement in this regard is, that in the High Court of Munan, that is in the Republic of Varanasi, the other parties have also filed for a bulk production, a license for bulk production of the same drug. And hence, there is a threat that materializes. And that is exactly what the council is trying to prove prima facie, is that a QRTMA injunction, your lordships and ladyships, is granted at a threat of infringement. Whether that threat will materialize in future is a moot question that need not be considered, if that answers your question, your ladyship.
Go ahead.
With the permission of the bench, the council would now like to cite the case of Fletcher versus Beeley as the second instance for filing the grounds of a QRTMA injunction. Now, Fletcher versus Beeley was a Chancery Division case which was substantiated in Dalpat Kumar and others versus Prahlad Singh and another. The three ingredients that the court considered in this case are irreparable damage, a prima facie case, and a balance of convenience in favor of the plaintiff. Now, the council has already established why a prima facie case rests, because in answer to the ladyship's question, the council had clarified that in this regard, if the council may continue.
We are coming to final stage. So where the question arises of interim injunction and all these three criteria to be satisfied?
To answer that question, your ladyship, the question before the High Court, first of all, the council clarifies that an ex parte injunction has already been obtained in the District Court of Surya by the plaintiffs. Furthermore, the same has been challenged before the Honorable High Court, and hence the grounds need to be defended. The same needs to be defended for the purposes of this case, if the council may continue with the concurrence of the same.
Okay, listen, forget about Fletcher, etc. Come to section 48. You tell me, how do you fall under?
Yes, should I read
The
it?
patentee's right has to come within the four corners of section 48.
Right. Yes.
Is that correct?
Yes.
So how would you, under which category of 48 would you fall?
Clarify, are you talking about section 14 of the Patents Act?
48.
48. Yes.
Yeah, obviously.
Yes, your ladyship.
This is the right of a patentee, right?
Yes.
So which category of, if you just come to the section, subject to the other provisions contained in this Act and conditions, etc., a patent granted under this Act shall confer upon the patentee, where the subject matter of the patent is a product. In your case, it's a product.
Yes, your ladyship.
The exclusive right to prevent third parties who do not have his consent from the act of making, using, offering for sale, selling or importing. These are the only four categories that you can stop.
Yes.
Right? So how do you bring yourself within this section in a QRTMA?
As your ladyship very correctly pointed out, and in concurrence to what I have previously stated before the court, the moot question here in this issue is a QRTMA injunction. Now, to satisfy the substantiation laid down in section 48, the last point states that the marketing goods within the territory, if the council is correct. And if the council may draw a parallel between this and what a QRTMA injunction is granted on, the basis, the main ingredient and the essence of a QRTMA injunction, to the pleasure of the bench, is that a QRTMA injunction is granted, the council clarified, for a threat of infringement as opposed to an actual threat materializing. And on that ground, the council pleads the same. If that pleases your ladyship.
Okay, please proceed.
Thank you, your ladyship. Coming down to substantiating the grounds laid down in Fletcher versus Beeley case, the first is the balance of convenience, a prima facie case, and irreparable damage. The council already substantiated the first two. Coming down to the third point, that is of irreparable damage being caused. Now, damages are, in this case, cannot be substantiated only on financial grounds. What the council pleads in this regard is that for a country as well as for a university, the knowledge resource is of paramount importance. In this case, the party I am representing is a university, as unlike to the defendant's party, which is a multinational company whose interests lies in profit making. The interest of the university lies, on the other hand, is to increase the knowledge resource of the country. The knowledge capital needs to be harped upon and kept in mind.
Don't you want to make money from this patent?
To answer that question, your ladyship, the BZ Meet University is not capable as per
so
se
therefore,
of...
why don't you license it to them?
Exactly.
Instead of an injunction, why don't you take royalty from them?
To answer that question, your ladyship, BZ Meet University is a university that rests in Varanasi, has been founded in Varanasi. So, giving the patent to an international company, your ladyship, is something that goes against the ethos of a country. in the Republic of Varanasi, which is a developing country, the intellectual property resource must be harped upon. Money is not the only consideration. Our country has seen multifarious cases of brain drain that has been happening, and in the interest of public litigation, in the interest of protecting the intellectual property of the country per se, the university wants to make elaborate contributions to the society.
So you will be willing to give it to a Varanasian company?
Yes,
Not a
Your
foreign
Lady,
company.
not a foreign company, Your Ladyship, if that might please the court. Coming down to the last point as to why a QRTMA injunction should be granted, is that if Your Lordship were to observe the present Novartis cases, 2014 cases very recently that came up, a host of interim injunction was obtained by Novartis against companies like Bajaj Healthcare, Alembic, Glenmark, on the same grounds, prima facie the same grounds against the anti-diabetic drug Bledagliptin. And hence the essence of the counsel in resting his argument before this court on basis of an assumption, a threat of infringement, has already been upheld.
You will run out of time, so go to your next issue.
Yeah, I will, thank you, if that pleases the court. Coming down to the next issue, as to whether if a pre-grant appeal has been filed, a post-grant should subsequently be refused. To answer the question of law, Your Ladyship, the counsel concurs that there is nothing that stops a party from consequently filing a post-grant opposition if a pre-grant opposition is already in place. But having said that, there are other grounds on which the court should take a cognizable measure and be cautious about granting a post-grant opposition. And if Your Ladyship would cite the cases of Bayer's Corporation and Novartis, the court has time and again harped upon the factor of public interest that comes into question. Now, an international company manufacturing the drug, even in the case of the cancer drug, the court had said that in a developing country like Varanasi, public interest should be kept in mind and is of paramount importance in deciding the affordability of the medicine per se. And also furthering it on basis of case law, that is in the Bayer's Corporation, the court said that public interest must be of paramount importance in the grant of a patent. If that satisfies the cause of the court, now the counsel would like to move on to the prayer. Moving on to the prayer, Your Ladyships and Lordships, the counsel pleads that the ex parte injunction that has been granted be maintained and any other remedy in the interests of equity and natural justice. Thank you. It has been an honor.
Permission of the bench. Good afternoon, bench. The counsel seeks permission to address the bench as Your Lordship. Much obliged, Your Lordship. Your Lordship, this is the counsel appearing on behalf of the Bristol Pharmaceuticals in the original appeal and original revocation application before the Honorable Intellectual Property Appellate Board of Varanasi. Lordship, the counsel will be dealing provide a proof of right if the assignment is not in place and the inventors are not traceable, and whether the ownership can be concluded from other circumstances. To support the argument, the counsel would like to humbly submit that if we read the Section 7, Clause 2 of the Indian Patents Act, along with Rule 10, it makes it very clear that a proof of right to apply is a mandate, because the word used in this provision is shall, and there is no exception to the same. And Your Lordships, if we may kindly refer to the case of NTT Docomo versus the Controller of Patent and Designs, which is a recent judgment of 2013 before the IPAB itself, the counsel contended that if a person is able to prove a right, then he need not apply, Your Lordship. Your Lordship, however, this contention was not accepted by the court, and this case was in regard of conventional application, that in those applications, the proof of right to apply must not be provided, because in the other countries, exception was not provided, Your Lordship. So it is very clear that in all cases, a proof of right to apply shall be provided, and there is simply no exception.
But weren't these people employees of the university?
Indeed.
So as per their rules of employment, any invention which they do, I'm sure that's the case even with Bristol. Your researchers, whatever they do belongs to Bristow, isn't it?
Indeed, Your Ladyship. These people, they had an employment contract. But this employment contract in itself is not an assignment. It's just an agreement to assign their patent, Your Lordship. And in these cases, in the past,
Where do you get that from, that it's only an agreement to assign?
Your Lordship,
The facts don't say so.
Your Lordship, in principle of law, an employment contract cannot be considered an assignment because there are certain conditions for an assignment which have been mentioned under the heading of registration of patents, though in section 68 and 69 of the Patents Act, that it must be in writing and it must contain all the rights and duties and have been duly executed, etc., etc., Your Lordship. However, the Council also like to bring to the attention of the Honourable Board the cases of XXX Safety Glass versus Curro and Barrington versus King, which have been cited in the Indian books. If Your Lordship would be kind enough to refer to the book that the Council would be providing. In these cases, Your Lordship, such an issue was raised before the in England, where it was held that a employment contract is not enough, and in cases where if the employer refuses to accept to sign the assignment agreement or assign the patent, the employer has to file a declaration suit and
So
get
according
it.
to you, who owns the patent?
Your Lordship, until unless there is an assignment, it will belong with the true and first inventor.
So is it your case that Bristow owns the patents now?
No, Your
Because
Lordship.
they're working with you.
No, Your Lordship, we never said that they are working with us. There is no statement in the fact sheet to say that they are working with us. We never said this patent belongs to us. What we are saying is that there is a procedural fault which is very important for any patent to be granted in order to protect the rights of the inventors also. Therefore, since there is a procedural lapse, this patent cannot be granted, Your Lordship. That is what the Council has clearly contended. And Your Lordship, since it is very clear that in what form proof of right to apply can be provided and none of that is present here, there is absolutely no scope to differ away from what our law says, Your Lordship. Therefore, there is a need of a proof of right to be right to apply to be provided in form of an endorsement in Form 1 or an assignment deed, none of which has been done. And in fact, the opposition board clearly said that that this employment contract won't ipso facto, and in fact the past applications won't ipso facto grant these people the right to apply. Also, Your Lordship, the Council is not able to recall the name of the case. However, there are cases in foreign jurisdiction which says that in deciding whether a person has a right to apply or not, past applications cannot be taken into consideration as well, Your Lordship. Also, we need to look at the consequences of the same, Your Lordship. If in a case, if today the board decides that an employment contract is enough of proof of right to apply, what can happen in future is that if an employee signs an employment contract with the employer and they need not obtain his signature every time for a new
So are you
patent.
saying that the patent subject matter is in public domain? Because the inventor doesn't own it, the university doesn't own it, Bristow doesn't own it, who owns it then?
Inventor, Your Lordship, the Council says unless they have been properly assigned, it is the true and the first inventor. Bristow has absolutely no stake here, Your Lordship.
Okay.
Moving on, Your Lordship, the Council was pointing out towards the consequences of what will happen if this is to be accepted as enough a proof of right to apply, Your Lordships. If once the employment contract is signed with an employee and the employer need not go to him for every patent to get his signature on Form 1 or an assignment deed for that particular patent, but it will become a tyranny that they'll just get the employment contract signed once, and after that the moral rights of the patent, these true and the first inventor, they cannot be protected.
Sorry, there are no moral rights in patent. There are moral rights and copyrights.
Your
There are no
Ladyship,
moral
moral
rights
right of the true and first inventors refer to his right to be recognized and
His
to
name
get
is
the
there on the
compensation.
patent. Nobody is saying his name
Indeed.
is not there.
Indeed, Your Ladyship, the Council said, and to get the compensation, to get the appropriate reward for his invention, Your Ladyship. So in order to protect those rights, it is necessary. If Your Lordships are satisfied with the issue, the Council much obliged, Your Ladyship. Your Ladyship, the next issue is regarding the obviousness in this case, whether to exactly quote the same, obviousness in case the level of skill is high, Your Lordship. The Council humbly submits that the compound I, that for which the invention is being claimed, it is an obvious compound. That is so, your lordship, because there are prior arts available. There is compound T as sought by Hensky, which is much similar to the compound I which these people came up with. There are prior publications by the inventors themselves as well as other patent applications. And in fact, the Indian patent application application, as has been mentioned in the exhibit, it also...
Under which section is obviousness covered under our Patent Act?
Your ladyship, for revocation it is under 64(1)(e), and under 3D also it talks about efficacy, which also leads us to obviousness, your ladyship.
No, 3D doesn't lead to obviousness.
It talks about efficacy, which is a factor in obviousness, your ladyship. 64(1)(e) regarding revocation, obviousness is a ground for revocation there, your ladyship. Your ladyship.
And inventive step?
Your ladyship, the council would like to refer. The council is confused among the subsections regarding the same. Your ladyship, as the council stated, there is not much structural difference in what was taught by the compound T, which was taught by Hensky, and the compound I, which was taught by which these people claim to have invented, your ladyship. And the patent application, Indian patent application which was filed, it said that in compound T, if a lower alkyl group is placed, then it will not have side effects. However, if
do you have any material to show? Come to page 5 of the
Indeed,
fact.
your ladyship.
Because you're arguing obviousness, I need you to give me some material.
Indeed, your ladyship.
Is there any material to show that the addition of the cyclopentane ring before the methyl was known under the teaching suggestion and motivation test, the TSM test? Adding of the cyclopentane ring was obvious. Do you have any material to show that?
Indeed, your ladyship, the council would just guide towards the particular paragraph which talks about a prior patent application which was filed, which said that on page number 12, it said that a lower alkyl group must be attached to a 5-member ring, and then and if a higher alkyl group is attached to a 5-member ring, it decreases the activity of the compound. So it pointed out towards the lack of,
But this was the prior art which the patentee himself cited, isn't it?
Indeed.
You're referring to the first paragraph of page
Indeed, your
12.
ladyship, but
So they themselves cited it.
Indeed, your ladyship, but they refused to take the Teaching Motivation Suggestion Act, which your ladyship just accepted towards to the same, and therefore this will now stand. It did not stand because the controller refused to accept the Teaching Motivation Suggestion Act, saying that it is alien to Varanasi. However, there are case laws wherein this test has actually been
What is
used.
the other alternate test, if not TSM test?
There is Graham test and there is problem solution test as well, your ladyship.
Which jurisdiction follows problem solution?
Your ladyship, the council is not aware of. Okay. Much obliged, your ladyship. So, your ladyship, and in fact, the replacing of methyl and ethyl, it cannot be taken as an obvious step because it is a derivative of the same, and therefore, any change which has been there is not a very novel change, and it could have been anticipated in light of the prior art publications, etc. Your ladyship. Therefore, this.
Okay, now come to section 3D because you're raising this as a main issue.
Indeed, your ladyship.
Do you think the two structures which are at page 8, which I just showed you, page 5,
Indeed, your ladyship.
do you think these two belong to are the same substances? Because 3D applies only when it's the same substance. Because otherwise, you cannot say that 3D will apply. How do you say that the two structures are the same substance?
Your ladyship, the council would just like to refer to. Your ladyship, it also talks about mere discovery of a new form of a known substance.
Right. So, is it a new form of a known substance?
Your ladyship, if we look at the structure of the same, even the earlier compound which was there, it was used in a painkiller. Even this is there. So the nature is essentially same. And if we look at the changes that have been made, here ethyl has been replaced by methyl. That is one change. And this benzene ring which has been, methyl benzene ring has been added. So essentially, there is no invention, nothing which is exceptionally new. Here it's a new form of the same when we are making minor changes in the same, your ladyship. So the minor changes in the structure that were anticipated, that could have been anticipated, are there. Therefore, the council said so. Your ladyship, moving on to the, if your ladyship is satisfied with the same issue, the council seeks permission to move on to the next issue. Your ladyship, the next issue is whether prior publication by inventors can defeat novelty or not, your ladyship. Your ladyship, under section 29, which talks about anticipation by a prior publication, the council humbly submits that prior publication here will defeat novelty, because section 29, which talks about anticipation by prior publication, it mentions two of the exceptions to the same. That if his work is published without his consent, and that if it is regarding, if it is a application regarding the same invention. So publication with his consent is not mentioned as an exception here. Now moving on to section 31 clause D, which talks about publication before a learned society. Even that won't apply here, your ladyship, because in the transaction, when we talk about section 31 clause D, it talks about learned society and the transactions of learned society. Therefore, the publication which is there, it has to be limited to a number of people. However, in our case, it was made open to the public. So there also, it won't fall. Now, what we have to look into here is that draft manual of the Patent Office 2005, it included an express precaution, your ladyship. The council would quote the same from the memorial, page number 26. It says that it is a common experience that through ignorance of patent law, inventors act indiscreetly and jeopardize the chance of obtaining patents for their invention. The most common of these indiscretions is to publish their inventions in newspapers or scientific and technical journals, your ladyship. Now, since these people have done so, in fact, the book that the council just provided, and the council has flagged for the same, even in the book, the author expressly quotes the same thing, that the inventors must not publish their inventions in a journal or a newspaper before getting the patent or before filing the application, because it can defeat the novelty. So in light of all these things, here the novelty gets defeated, your ladyship. And talking about that it being a provisional conclusion only, your ladyship, the provisional conclusion was titled, and it talked about...
I have a question. You are saying that this university did not do anything to come to this invention. You're a big multinational company, and Hensley was known to you.
Indeed.
How come you didn't arrive at this drug?
Ladyship, every company need not... was obvious, and we never felt the need to file a patent for the same, because it is in the common knowledge. So there is no need to file a patent for the same. That is why we have just mentioned it on our website. We are applying for the licenses, etc., your ladyship. Now, your ladyship, even talking in the rare case that it is a provisional conclusion and therefore won't anticipate. Talking about that, ladyship, in the case of Merrill Dow and General Tire, it was made very clear that if the information which has been disclosed enables the public to know the product under a description, and since the provision...
We'll read the case laws that you've cited.
Indeed, your ladyship, the council was just stressing on few words. So and the provisional conclusion, your ladyship, which has been cited, it says provisional conclusion regarding a painkiller employing ABC receptor antagonist. It is the same with which they have obtained they are trying to obtain a patent, your ladyship. So since they've already disclosed the product, so it is now in public domain, and it has been, now it will anticipate that the patent application they filed a year after the same. Therefore, the novelty gets defeated, your ladyship.
So why have you filed a post-grant and an appeal against that, as also a revocation? So you're happy if we dismiss the revocation and only entertain the appeal and decide the appeal against the controller's order?
Your ladyship, the grounds which can be raised in revocation are wider than section 25 clause 2. Also in an appeal, you can only raise the grounds which you...
So will you withdraw your appeal for the post-grant and only stick to the revocation? You can't have both, right?
Your Ladyship, since in the present case the IPAB was kind enough to club both of them and hear us on both of them, and the remedy that we are seeking under both of them is the same, that this patent should be revoked now. So the council, and since the bench was kind enough to already hear the same, the council would pray that it be proceeded with. Much obliged, Your Ladyship. Your Ladyship, now the last issue, that if a post-grant opposition has been filed, can the same party file for a revocation and challenge the patent in a counterclaim for infringement? The council will be dealing with this question in two steps. Firstly, that if a post-grant opposition has been filed and is pending, and can the revocation be filed, revocation or counterclaim?
First of all, I have a question for you on the post-grant. Is the controller bound by the recommendation of the opposition board?
Indeed not, Your Ladyship.
You're sure about that?
Indeed. It has a high persuasive value because the opposition board consists of the member who hold expertise in the invention for which the board has been constituted. However, the controller himself is also a person skilled in the art, as the controller. I am also a person skilled in the art, Your Ladyship. So he is not bound by the same. Moving on, Your Ladyship, to the first part, the grounds for infringement and the post-grant opposition, they are different. The time within which they can be filed is different. As the post-grant opposition is limited to just 1 year, you can file it within 1 year of grant of patent, while the revocation can be filed anytime within the life, Your Ladyship. Therefore, the simultaneous proceedings are not bound. In the case of Suratmal Rambaks versus Lakshmi Narayan Raghunath High Court case, they said that if a person has been unsuccessful, that if a person has unsuccessfully opposed the grant of a patent, there is nothing that stops him from filing a revocation application, because the grounds are different, these are different, Your Ladyship. Now moving on to the second part, that whether revocation application and counterclaim for infringement can be filed together, Your Ladyship. Your Ladyship, here the doctrine of application of election has to
I think you're getting too many chances to challenge the patent. You lost in the pre-grant, you lost in the post-grant, now you want to file an appeal against that, and then file a revocation. So aren't you getting too many chances on the same patent with the same material?
Your Ladyship, since patent is granting a monopoly right, and we need to take into consideration the rights of the public, and especially in the pharmaceutical industry and in patent, because patent grants a monopoly right. Therefore, the 5-tier level of checks has been granted by the statute. Therefore, the council has a statutory right, and the council would now prove that why both revocation and counterclaim can be filed by the party. Much obliged, Your Ladyship. Your Ladyship, we need to keep into mind the doctrine of election here. In the case of Transco versus Union of India, while dealing with the issue of DRT applications and SARFACI Act applications, which seek to get the same remedy, that is, get the money of the bank back to them, which the person has failed to pay. Your Ladyship, they clearly said that the doctrine of election of remedies, there are 3 elements which need to be proven. That firstly, there should be more than 2 or more remedies, there should be a choice between them, and there should be an inconsistency between them. And if these 3 conditions are fulfilled, then only a party can be forced to choose one of the remedies. However, Your Ladyship, in the present case, the remedies that the revocation application and counterclaim for infringement seek, the remedies are the same. Therefore, there is no inconsistency between them. And in fact, the court went on to say that in case of alternative or concurrent remedies, Your Ladyship, just as in our case, we have alternative remedies. The bar is until the satisfaction is reached. Till the time the party does not feel that justice has been done, because, Your Ladyship, justice must not only be done, but it must be seen to be done, Your Ladyship. Therefore, keeping in mind this factor, and the party has this right, and also, Your Ladyship, the party should have gained an advantage and the other party should have suffered a disadvantage. Till now, there is nothing which has been decided in our favor. The bar for us remains satisfaction. Therefore, we can go on to file a revocation application as well as a counterclaim for infringement, because the doctrine of election does not apply on us.
If you lose, we can impose very heavy costs.
Your Ladyship, the council agrees for the same. However, the council believes that the council has strong case since all these remedies do not
conclude now.
Much obliged, Your Ladyship. The council now seeks permission to move on to the prayer, Your Ladyship.
We've read it, no more.
Much obliged, Your Ladyship.
Thank you. Yeah, it's good. Did she have any response there? How much time was there? If they need time in rebuttal.
For the sake of convenience, the counsel would like to refer to the bench collectively as Your Lordship. Much obliged. Your Lordship, I'm Speaker 1, appearing on behalf of Mate University in the matter pending before the Intellectual Property Appellate Board of Bharnesia. Your Lordship, I will be dealing with the first 4 issues. These are whether the Patent Office can conclude ownership of a patent in absence of a valid assignment. Issue 2, whether the impugned invention can be termed as obvious, keeping in mind the high level of skill. Issue 3, whether the prior publication by inventors can defeat novelty. And issue 4, whether the dismissal of pre-grant opposition bars a post-grant opposition primarily on the same ground. Your Lordship, my co-counsel will be dealing with the final 2 issues. If Your Lordships are satisfied, could the counsel proceed with issue 1? Much obliged. Your Lordship, issue 1 pertains to the question whether the Patent Office can conclude an ownership of a patent in absence of a valid assignment. Your Lordship, the question as to whether the invention developed by the employee during the course of his employment should belong to the employee depends on the contractual relationship between the employer and the employee, either expressed or implied. Your Lordship, citing the case of Solomon versus Solomon, which is on flag 12, as well as footnote 3, page 1 of the written submissions of the respondents, it was held that an employee performing all the duties assigned to him in his department of service may exercise his inventive faculty in any direction he chooses, with the assurance that whatever invention he may thus conceive and perfect his individual property. However, this general rule is subject to the following limitation. If one is employed to devise or perfect an instrument or a means for accomplishing a prescribed result, he cannot, after successfully accomplishing the work for which he was employed, plead title thereto as against the employer. If Your Lordships are satisfied with the counsel. Your Lordship, in another case, in National Day of Corporation versus Gray, Your Lordship will be very kind to refer to footnote number 4. It was held that if the employee fails to reach his goal, the loss is on the employer. But if he succeeds in accomplishing the prescribed result, then the invention belongs to the employer, even though there is no terms of the contract, no express provision stating the same. Now, Your Lordship, coming to the facts of the present case, the standing rules of the employment of Mate clearly stipulated that all the intellectual property generated by its employees would belong to Mate University. Your Lordship, further, the 2 inventors, Professor M. Vaidya and P. Bhattacharya, were employees of the Mate University and were legally bound by the same contract, which specifically stipulated that whatever they produce, whatever they generate, whatever they discover would in fact belong to the university. Your Lordship, also further stating that they were well versed with their rights. They have been working in this particular field for a very, very long time. They were well versed with their rights. If they in fact had an objection to Mate getting the patent, they would have themselves approached the Patent Office on the grounds of wrongfully.
Did you tell them before filing the patent application?
Your Lordship, the fact sheet is silent on that. However, whatever was discovered in the previous, it's also stated in the previous situations, whatever is discovered is patented by Mate University in the name of Mate University.
How would you respond to your colleague's argument that this kind of a thing constitutes tyranny on the inventors and takes away their moral rights?
Your Lordship, the council would like to state that this, while becoming a part of the university, they knew what was written in the employment. It was their consent, and it was their consent that they in fact signed it. That goes on to prove that they in fact did not have any problems with Mate owning their patent. So therefore, Your Lordships, the council would just like to say that both the inventors in fact conceded to the fact that they don't have any problems and whatever they invent would be owned by Mate University. Your Lordship, also stating that section 68, which talks about an assignment and essentials of an assignment, there are 2 essentials. There has to be an agreement, and the agreement has to be in writing. Your Lordship, the employment, the standing rules of the employment, the contract of employment is an agreement between both the parties, the university and the inventors. And in fact, it is in writing. Therefore, the council would like to say that the assignment is valid assignment. Thus, it is humbly submitted that the standing rules of employment of the university.
There is no section equivalent to section 17 of the Copyright Act in the Patent Act, right? Section 17 of the Copyright Act says anything done during the course of employment, etc., would belong to the employer. But that section and provision is absent in the Patents Act.
Indeed.
So therefore, don't you need a specific assignment every time you apply for a patent? Did you file the contract of employment with the patent application?
Not with the patent application, but the proof was given later on, where we claimed that it was a mere oversight, after which we submitted the further documents, to which the controller agreed. The controller actually objected this particular issue, but after Mate submitted the further proof, it agreed to the fact that it was a mere oversight. And it was not a deliberate, there was no malified intention on the part of Mate.
Are you willing to say forever, suppose you license this technology to somebody or to launch a product on this painkiller, are you always willing to give credit to this inventor, saying that these are the two people who...
Indeed we are, Your Lordships, and that's the reason why the name of inventors is mentioned, and not only this, in all the other previous patents, the name of the inventors is mentioned. We are not taking away the hard work that the inventors have put in. All we are doing is we are enforcing the contract, the contract of employment. The patent will be owned by the university. However, we are not taking away the hard work that the researchers have put in to develop the same.
Does your contract of employment have a sharing of royalty?
Your Lordship, the fact sheet is silent on
So
that.
then it's a one-sided contract.
With the council.
Right, go ahead.
Much obliged. Your Lordship, the council would like to proceed with the second issue. The second issue deals with the question whether the impugned invention can be termed obvious, keeping in mind the high level of skill. Your Lordship, the plaintiff has put forth three major objections to the grant of the impugned patent. These are as follows. First, that the claimed compound is obvious in view of earlier disclosure and inventor's own earlier publication relating to neuropathic antagonists. Second, that the claimed compound is a new form of a known substance, compound T, disclosed in prior art. The claimed compound of Formula 1 has almost negligible structural and functional difference with compound T. And finally, that the invention does not involve an inventor set. Your Lordship, these three objections are wholly dispensed with the following sub-issue. Your Lordship, beginning with the first sub-issue, whether the impugned compound is obvious in view of the inventor's earlier publication. Now, Your Lordship, would be very kind to refer to footnote number 9, page 4 of the written submission. In Cruz's application, the court held that although the device may seem obvious in retrospect, if it had never occurred to the opposition or anybody else until the applicant's device had received some publicity, the opposition may not succeed on the grounds of obviousness. Your Lordship, further citing the judgment of Ryko Manufacturers in another, which is flag 8 of the compendium, it was held that instead of ascertaining what is subjectively obvious to the inventors at the time of the invention, the court must ascertain what would have been objectively obvious, apologies, Your Lordship, to one of ordinary skill in the art at such time. Now, Your Lordship, the facts of the present case were that the two scientists were in fact highly skilled, and stating that their invention is obvious would be nothing short of travesty, Your Lordship. In fact, the council would like to state that it is their high skill that they could come up with such a drug, they could come up with such a conclusion.
Is the test of obviousness in the United States and in Bharaneshia the same?
Your Lordship, the council would they're not paramateria. However, the council cited this judgment because...
what is the test of obviousness which is followed here?
In view of prior art, Your Lordship, they see section 3D, and if it's patentable...
3D doesn't relate to obviousness. 2JA relates to obviousness.
2J8
So
talks
what is the
about
test of obviousness?
inventive step, Your Lordship.
Yeah.
21J8 talks
2J
about
is about
inventive step.
step,
It
which
gives
is
the
obvious,
definition of inventive step.
which is
Indeed,
obviousness.
Indeed,
right?
Your Lordship, it gives the
So
definition.
what is the test of obviousness which is to be followed here?
Your Lordship, the particular claimed compound should not be obvious to the person skilled in ordinary art. The person skilled in
Do
that
we
particular
follow
field.
TSM? Do we follow problem solution? What do we follow?
Your Lordship, the court has taken both the stand. The council does not have
Can
a
you
judgment.
cite any judgment on obviousness?
And
The test which is to be followed in
Your
obviousness.
Lordship, the council does not have a judgment for
Okay.
test of
Go ahead.
obviousness. If the council could continue with the submissions, much obliged, Your Lordship. Now, Your Lordship, the council would go on to cite another judgment, footnote number 15. It was said that the fact that the inventor himself may not have found difficulty in arriving at this invention is irrelevant. The question is whether the invention is legal in sense, that is regarding the matter objectively made by him having regard to the existing state of knowledge. An inventor may well arrive at his invention by a flash of genius, which causes him no difficulty or concern thought at all. But the invention may still be most brilliant one which would have never occurred to the notional skilled man in the art at all, or only after a prolonged investigation at the concerned exercise of his perhaps lesser inventive faculty. Your Lordship, in such a case, though it's a sense of obvious to the inventor, nevertheless it cannot be considered as not worth of protection, not worthy of protection, Your Lordship. Your Lordship, therefore, is a humble submission that in the present case, the standard of obviousness must be an objective one, one on common knowledge and common sense of a person ordinarily skilled in the art, and therefore declare the impugned invention as not obvious. Your Lordship, going on to the second sub-issue is whether the compound falls within Section 3D of the Indian Patents Act. Now, Your Lordship, according to Section 3D, to be patentable, an invention which is in structure similar to the art must show efficacy. In the cases of pharmaceuticals, we talk about therapeutic efficacy, which is defined as the two essentials. First, the ability of the drug to achieve the desired effect. Second, the degree to which an intervention accomplishes the desired or projected outcome. Now, Your Lordship, in the present case, the prior art mainly faced two problems. First being the side effects such as drowsiness, dizziness, fatigue, headache, increase in societal thoughts, nausea, vomiting, etc. Now, Your Lordship, there was a need, and I would like to concentrate on the fact that there was a need for a medicine which would provide for mood elevation, as it is very important in conditions such as chronic pain, because it often leads to depression and trauma, Your Lordship. Now, Your Lordship, the problem was in fact solved by our drug. If Your Lordship would be very kind to refer to figure 13 on page 24 of the fact sheet, Your Lordship. Your Lordship, the fact sheet makes it clearly shows that with time, the drug so to be patented not only significantly...
How do you measure mood elevation?
Your Lordship, through experiments.
What kind of experiment?
Testing, Your Lordship.
Your chart on page 24, what is it based on? What kind of test can you perform? Check whether somebody's mood is elevated or not.
If the council could just get a second. Just a minute. Your Lordship, as far as the council has understood the problem, this is the result of the experiments that were made by the university.
Right.
The experiments are made through testing, the details of which the council cannot provide.
Okay, go ahead.
Much obliged, Your Lordship. Your Lordship, the second problem was the difficulty to administer, especially in case of geriatric and pediatric patients, as they were not available in different formulations. The same is again solved by our drug, as it's available in different forms, such as liquid, powder, exhaler, injectable solutions, suspensions, and syrup. Your Lordship, thus, it is a humble submission of the defendants that with this proof provided, there has been therapeutic efficacy, and the impugned drug is thus patentable. If Your Lordships are satisfied, could the council move on to the third and final sub-issue? Much obliged. Your Lordship, the third and the final objection was raised as to a lack of inventive step. Now, Your Lordship, Section 2(1)(j) of the Act defines inventive step. An inventive step means a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance, or both, and makes the invention not obvious to the person skilled in the art. Your Lordship,
according to me, dealing with obviousness and inventive steps separately is incorrect, because inventive step is the broader genus. Obviousness is one part of it. Section 2(j) says something which is obvious does not have an inventive step. It has to have a technical advancement and should not be obvious. So, inventive step is the major genus, and technical advancement and obviousness are two species within that.
Indeed.
Right? So, you've dealt with obviousness earlier. You
Indeed.
have to come to technical advancement as compared to existing knowledge.
Indeed.
Yeah, please go ahead.
Your Lordships, the council would like to say the advantages of the particular medicine is that it interferes with the brain transmission, Your Lordship. It does not cross the blood-brain barrier and thus does not affect the central nervous system, accompanied with the fact that it leads to mood elevation, And that the council has already cited, it is available in various forms. The bioavailability of the present drug is very high, as it can be taken as oral administration, intravenous, intramuscular.
But the Novartis judgment specifically says bioavailability is not therapeutic efficacy.
Your Lordship, the council is stating that along with the fact that the blood-brain barrier issue that the council has already stated, the mood elevation, another advantage of our drug.
So bioavailability is just one part.
The council is stating it's another advantage of the present drug. Your Lordships, could the council continue? Your Lordship, therefore, it's a humble submission of the defendant due to all these aforementioned reasons, there does exist an inventive step in the impugned compound. If your Lordships are satisfied, the council like issue. Much obliged, Your Lordship. Your Lordship, issue 3 deals with the fact of whether the publication can defeat the purpose of novelty. Now, Your Lordship, under patent law, in order to render a document not novel on the basis of the publication, it must be proved that the publication was an enabling disclosure. Your Lordship, now the council will be dealing with the question what is an enabling disclosure and whether the publication made in the present case was in fact an enabling disclosure. Your Lordship will be very kind to refer to flag 1 of the compendium, footnote number 25 of the written submission. Your Lordship, an enabling disclosure will destroy novelty if the public is given sufficient information to enable the invention to be put into effect. Thus, that is, a disclosure will anticipate an invention if it...
Flag number?
Your Lordship, flag number 1 of the compendium, footnote 15. Footnote 25, apologies, Your Lordship. Could the council continue?
Yeah.
Much obliged. That is, the disclosure will anticipate an invention if it enables the invention to be worked or practiced. Your Lordship, in another case it was held that an invention is not made available to the public merely by a published statement to its existence, unless the method of working was so self-evident as not to require any explanation, Your Lordship. Now, Your Lordship, in the present case, it's a humble submission that what was published was a provisional conclusion on a possible painkiller. Your Lordship, I would like to harp on the word possible. Your Lordship, therefore, since the word possible is already given, it cannot be considered to be an enabling disclosure. What was given in the publications were not details of the invention, were not details on how to come up with the patented product. With a mere conclusion.
Why does the patent law require an enabling disclosure?
Your Lordship, the purpose of enabling disclosure here is if any publication is made, it would make the patent and people would anticipate it. For someone to prove that the patent was not anticipated, they have to prove enabling disclosure. Enabling disclosure in the sense that the disclosure was of such nature that would enable a person ordinary skilled in the art to come to the conclusion that was given in the publication.
See, the purpose of giving an enabling disclosure in a patent is because if you go to the basic logic of a patent, the patentee is disclosing his invention to the public. The public should be able to make that compound or that substance. That's why it's called an enabling disclosure. That's why if there is no enabling disclosure, there is no actual disclosure. That's the point.
Indeed, Your Lordship, that is what the council is. That's what the council's contention is. The present publication cannot be considered as enabling disclosure, and thus it does not affect the novelty of the product at all.
Right.
That is the contention of the council. Much obliged. Your Lordship, in another case, footnote number 30 of the written submission, it was held that prior publication, defeat a patent must exhibit substantial representation of the invention in such full, well-earned and exact terms that one skilled in the art may construct and practice the invention without having to depend either on the patent or his own inventive skills. Now, Your Lordship, it is most humbly submitted that in the present case, firstly, the use of the word possible clearly shows that such a disclosure was not made. And secondly, the fact that the inventors themselves produced the drug almost 1 year after the enabling disclosure was made goes on to show that the conclusions were not enough to come to the patented product. And therefore, it's the humble submission of the defendants that the same should not be rendered as not novel on mere basis of the prior publication. If Your Lordship is satisfied, the council would like to move on. Lordship, the final issue that the council is dealing with is whether the dismissal of pre-grant opposition bars the post-grant opposition on primarily the same ground. Your Lordship, pre-grant opposition has been given under 25 clause 1 of the Patent Act and post-grant opposition has been given under 25(2) of the Patent Act. Now, Your Lordship, in the present case, the appellants had already unsuccessfully filed for a pre-grant opposition, and then they moved on to the post-grant opposition. Your Lordship, the Council would like to state is both these remedies are made available for different group of people. Your Lordship, 25(1) talks about any person, whereas 25(2) talks about only an interested party. Your Lordship, further stating raising of the same issue in front of the same authority would just waste the time of the court. It would be vexatious, and therefore the Council would like to submit that the same should not be allowed. This is the humble submission of the
But the legislature doesn't say so. A person can be covered under any person and under person interested. The Act doesn't say that you can only avail one or the other.
Indeed, Your Lordship, the Council understands that the Act does not say, but the Council would just like to add that the order of the Controller, which is given in Exhibit D, the Controller said that if the plaintiffs in the present case were agreed by the decision of pre-grant opposition, they should have availed the constitutional remedy of a writ petition.
There is no constitutional remedy available anymore for a pre-grant opposition. The Controller is wrong over there, because there's a judgment of the Delhi High Court which says that against a pre-grant order, you cannot come in a writ. It ends there. The only remedy therefore available is a post-grant or a revocation.
Apologies.
Yeah. The Controller was wrong when he said.
Apologies. Now, Your Lordship, the Council would like to just harp on the fact that the authority deciding the pre-grant opposition and the post-grant opposition were the same. The grounds were the same. Therefore, this would just lead to wasting the time of the court, because initially the grounds that were raised were dismissed. Your Lordship, Section 11 of the CPC.
Yes. Whether it will not apply?
Your Lordship, the IPAB is considered as a tribunal, therefore Section CPC would not apply. However, read with Section 151, which is inherent powers of the court, the principle of res judicata will apply. That is why the Council, that is why the Council is saying that the deciding authorities in both the cases are the same, Your Lordship. The same issues would just lead to wasting.
In res judicata, is it required that it should be the same forum?
Your Lordship, the essential is that the previous decision should be given by a court of competent jurisdiction.
Correct.
Apologies, Your Lordship.
Not coordinate jurisdiction.
For the same. It should be given by by a court that has jurisdiction.
And between the same parties.
And between the same parties, the same claim, same title. Now, Your Lordship, this was in the present case, the pre-grant opposition was given by the patent officer, by the controller of patents, and he had the authority to do the same. Your Lordship, that's all the Council. The Council would like to move on to the prayer. Much obliged. Therefore, in the light of the facts stated, issues raised, authority cited, and arguments advanced, it is most humbly prayed by the respondents in this matter that the Honorable Intellectual Property Appellate Board of Bharnesha may be pleased to declare the impugned patent valid and objections raised by the applicants as inapplicable. For this act of kindness, the respondents should forever humbly pray.
Thank you.
It was an honor arguing in front of this bench.
Much obliged. If it may please this honorable court, I am counsel appearing on behalf of the defendants in the present case in front of the Honorable High Court of Munich, Your Lordships, representing Bristow Pharmaceuticals in the present matter, Your Lordship. Now, Your Lordships, counsel will be dealing with issues 5 and 6 of the written submission, the defendant memo, Your
You need to
Lordships.
be show us which is your written submission, because there's too much confusion.
Indeed, indeed.
This
The
is
top,
yours?
indeed, indeed, Your Lordship.
This is yours.
Indeed.
Go ahead.
We are team SK02, Your Ladyship.
SK02, yes.
Much obliged, Your Lordship. Now, Your Lordships, the two contentions
would be, first, the fifth issue raised by Bristow Pharmaceuticals in the present case, that whether the same party has the twin remedies of revocation and challenging the patent in a counterclaim for infringement, having already filed a post-grant opposition. And sixth, whether a cure-time-at injunction, whether the injunction can be granted to protect the rights arising from a disputed patent. May the Council proceed with issue 5? Much obliged, Your Lordships. Now, Your Lordships, we deal with this in two parts. We first deal with the issues arising between the regarding the post-grant opposition and the revocation application in front of the IPAB, and then we proceed further. Now, Your Lordships, there exists nothing whatsoever in the Act, the Patent Act 1970, which states that once a post-grant opposition has been dismissed, it bars the party from filing a revocation application on the same grounds. If anything at all, Your Lordships, the grounds for the post-grant opposition given under Section 25(2) and the grounds given under Section 64, Clause 1 for revocation are quintessentially the same.
Have you read the judgment of Enacon?
Indeed, indeed, my lady.
Doesn't it say that you can only choose one remedy out of the other?
Indeed, indeed, my lady.
So how is your revocation maintainable in the light of the post-grant?
The Council would only like to submit two submissions here, my ladyship. First, that the Enacon judgment should not apply because, first, and this may be a very ancillary difference, but the ruling states that a person is barred from filing a suit for revocation if the post-grant opposition is pending before the patent office. In our case, this is not such, Your Lordships. The post-grant opposition has been dealt
but the
with.
judgment relates to doctrine of election.
Indeed,
You have to elect between post-grant or revocation.
Indeed, Your Lordships.
And would you elect with the appeal in the IPAB, or would you prefer to elect in the High Court? You have to choose between the two.
Indeed. Indeed, Your Lordships. Another reason why the judgment should not apply to us, Your Lordships, is that the facts of the two cases are not similar, Your Lordships. In the first case, the tussle, Your Lordships, the major tussle was between the true inventor and his employer, the employment rights, the contract of employment, and the patent and patentee rights arising from them. However, Your Lordships, the true inventors are not a party to this litigation in the present case, and hence it is the humble submission that the Enacon ruling should not be applied in the present case. Another thing that the Council would like to point out here, Your Lordships, is that quite surprisingly, the Bristow Pharmaceuticals and Mate seems to be in agreement on this issue, because if the Council may be allowed to point out. The written submissions given by the plaintiffs in the present case, Your Lordships.
Blue one?
Indeed.
Okay, which page?
Page number 28.
Okay.
My lady, after the bold part, if a post-grant opposition, the paragraph after that, the Council humbly submits that if a post-grant opposition under Section 25(2) has been filed by a party, it can still file for a revocation and also challenge the patent in a counterclaim for infringement. So, Your Lordships.
Yeah, haven't they said this because they are also appearing for Bristow?
No, Your Lordships.
Before
We are
the
the party.
IPAB.
No, but Your Lordships, in front
They
of the
have
High
said
Court.
this because they also appear for Bristow in the IPAB. You and them are appearing for the same party but different forums, isn't it? So this is not an admission in a contradictory position. No.
Indeed. Indeed.
It's an admission for your party itself.
Indeed. Indeed.
Right?
Much obliged, Your Lordships. Having said that, Your Lordships, the Council would now like to move on to the final.
You want to say something else on this? You can go ahead and say.
If there are any doubts that the Council could further dispel, Your Lordships, however, the Council would only like to reiterate the fact that the landmark Enacon ruling given by the Supreme Court of India in June 2014 should not be applied and should not be used.
Given a choice, would you prefer to go the post-grant way or the revocation?
Your Lordships, we would like to have the patent revoked.
Would you prefer to be before the High Court or before the IPAB?
Your Lordships, considering we would like to go before the IPAB, and we would prefer that the IPAB itself, being the forum, revoke the patentability.
In the post-grant?
In the application for revocation, my lady, the post-grant has already been dealt with. It has been dismissed.
No, you have a post-grant appeal, you have a revocation, and you have a counterclaim, isn't it?
Indeed, indeed.
So would you prefer to go in the High Court in the counterclaim or in the revocation stroke post-grant in the IPAB?
Your Lordships, considering that
Given a choice, which will you choose?
the Council would like to opt for the IPAB, Your Ladyship, having once dispelled with the patentability, the infringement claim itself would fall.
Okay, so you prefer to be in that.
Indeed, indeed. Much obliged, Your Ladyship. Now finally coming to the last...
Isn't there one major advantage you have in the High Court? Number one, the High Court is a court of superior jurisdiction.
Indeed.
Number two, there will be oral evidence in the High Court. But in the IPAB, there is normally no oral evidence. So wouldn't you prefer going the oral evidence way rather than the IPAB?
However, Your Lordships, the Council would also like to follow the hierarchy laid by the Act. The governing Act in the question is the Indian Patent Act 1970. And the Council would like to stick to the hierarchy laid by the Act.
One more chance. Come to High Court after IPAB decision.
That would be an added advantage, my lady. Much obliged. Now quickly coming to the last issue, Your Lordships. This would be whether a quietimate injunction can be granted to protect the rights arising from a disputed patent. Now, Your Lordships, what we are contending here is that once the patent is disputed, it should not be allowed to stand as a proof of validity. In simple terms, the circular argument should not be allowed to be taken that you cannot question the validity of my patent because my patent is valid. Acting on the same...
Which is a provision which says that there is no validity to a granted patent.
That would be Section 13, Clause 4, Your Lordships, if the Council may be allowed to quote.
Much obliged.
Lordship, Section 13, Clause 4 of the Indian Patent Act clearly states that the examinations and investigation required under Section 12 and this section shall not be deemed in any way to warrant the validity of the patent. Hence, Your Lordships, it is not a proof of validity.
See, this provision only protects the employees of the patent office. This
Indeed.
doesn't say the patent is prima facie invalid. Isn't
If the
it?
Council may be allowed to cite authorities, Your Lordships.
Yes.
Much obliged. Your Lordships, coming to page number 15 of the substantive sections of the defendant memo submitted by Bristol Pharmaceuticals. Your Lordships, this would be footnote number 41. The case of Bajaj Auto Limited, flag number 3 in the compendium, Your Lordships. The green fluorescent flag number 3. Much obliged, Your Lordships. Now this states that in suits alleging patent infringement, the court ought not to grant any interim injunctions in cases where either the plaintiff fails to prove a prima facie case or where the defendant presents a credible challenge. These would be the two sub-issues that we would be contending on, Your Lordships, and why the Council says that a prima facie case has not been presented is primarily on the ground of
the fact that you lost in the pre-grant
Indeed.
makes it a prima facie case, doesn't it?
Your Ladyship.
The patent is prima facie valid because you've lost in the pre-grant opposition.
The Council would beg to differ, Your Lordships. That would be because of the application of the 6-year rule which has been formulated by the court in the case of Manika Thakur. The Council may, Your Lordships, this would be footnote number 45 on page number 16 of the written sub.
Yeah, go ahead.
Flag number 7. Your Lordship, the figure in patent law can be traced to the 1965 decision of the Madras High Court.
No, go ahead, it's okay.
Goes on to say that the court will not grant an interim injunction in the case of recently granted patents, with recent being less than 6 years.
But Manika Tevar is under the old act. Now this is under the new act where you've had a pre-grant opposition.
Indeed, indeed, Your Ladyship.
So therefore there is a prima facie validity once you lose in the pre-grant.
However, Your Ladyship, the whole concept of the pre-grant opposition being added, earlier there used to be only one opposition given in the Patent Act. After India became a signatory to the TRIPS agreement.
Was that pre or post-grant under the old act?
My Ladyship, that was post-grant, if the Council remembers.
It was pre-grant.
It was pre-grant. The Council apologizes, Your Ladyship. Much obliged. The whole point was to give effect to Article 32, which said that there should be revocation procedures, Your Lordship, and that is why various revocation procedures at various different levels have been set up, Your Ladyship. However, the Council does not submit to the fact that simply losing in the simply losing the pre-grant opposition amounts to a prima facie case in favor of the plaintiff. Further, Your Ladyships, if the Council may cite one last authority, this would be on page number 17 of the written submissions, flag number 6, Your Lordships, flag number 6 of the compendium, the case of Soaps versus Hindustan Lever Limited. This is a case of 1994, Your Lordships, of the Calcutta High Court, hence under the new Act. This says that even if the plaintiff could establish a prima facie case where the patent is a new and recent one which has not been worked out as yet, the court has to consider this aspect before allowing it. Hence this has also been recognized under the new Act.
This is not the new Act. Godrej Soaps. The Act was amended in 1995, isn't it?
Right now, the Council to the 1970.
Okay. All right.
Much obliged, Your Ladyships. Good call, Your Ladyships. Wherefore, in the lights of the facts stated, issues raised, authorities cited, and arguments advanced, it is most humbly prayed by the defendants in the present case that the Honorable High Court of Munane may be pleased to, first, revoke the impugned patent, and second, invalidate the creatimate injunction granted in favor of the plaintiff by the District Court. That would be.
Would you like to have any rebuttal? You must tell us what is the exact issue on which you want to rebut and then answer.
Your Ladyship, this will be appearing before the IPAB, and firstly, first issue.
That's for Bristol.
Indeed, Your Ladyship, and we'll be dealing with the first issue, that is regarding the proof of right to employ, Your Ladyship. Your Ladyship, the Council would go point-wise. First of all, the Learned Council said that the employment contract is an assignment agreement because it is in writing, and it lays down the condition. However, Your Ladyship, for an assignment agreement to be valid, it must not only be in writing, it must contain detailed rules about the rights and duties as mentioned in section 68 of the Patents Act, rights and duties of the patentee, of the person who is being assigned the patent, and the person who is assigning the patent must be duly executed, and there are certain other conditions to the same. And therefore, the employment contract as such cannot be regarded as an assignment agreement. Second point, Your Ladyship, only said that...
Isn't it a technical defect which can be cured by them? Like in a plaint, suppose there's a no verification or no power of attorney filed. These are all held to be technical defects which the Supreme Court says can be cured at a later stage. So suppose they get the inventors to assign an agreement, so would you be satisfied with that?
Your Ladyship, the company would be more than happy if they get these people and get them to sign it. The Council, we said that these people are traceable, and we said the same. However, Your Ladyship, they claim it to be a mere oversight. And at the same time, they say that these people were well versed with the rules of the Patent Act. So well versed, and they're having filed hundreds of applications, this could not be a mere oversight. While filing such an important application regarding patent for which they would have worked for years, how could they miss signing his signatures? And for 2 years, Your Ladyship, in 2009 it was filed, the application was filed. And it was only in the year 2011 that the person objected. Your Ladyship, the Council would seek extra time. Much obliged, Your Ladyship. So it could not have been a mere oversight. And Your Ladyship, they say that when they agreed to assign their patent in the contract, and that is it, Your Ladyship, we need to look at the possibilities here, Your Ladyship, because they agreed to assign their patent. However, they did not agree to do so if they are not given the compensation or recognition. That is why it is required that in every patent that you seek, at every level there should be a check with an express declaration for each patent, Your Ladyship. That is why a proof of right must be required. And Your Ladyship, regarding the question of 1 year that they said that it was filed after 1 year, that cannot be considered conclusive that for 1 year they were experimenting. Maybe they were on a vacation, Your Ladyship. This is a novel argument that the council is saying unless they prove it before us, that for 1 year there were experiments going on. Moreover, Your Ladyship, they say res judicata will apply for pre-grant and post-grant, Your Ladyship. In that issue, res judicata won't apply because in pre-grant, a party, the person objecting is not a party itself. The party is the controller. And therefore, if the parties are not same, it won't apply, Your Ladyship. And before the High Court, the only thing that the council would like to rebut is that they say the Anacor judgment won't be applicable. However, Your Ladyship, it will be applicable because it was a very clear ruling. It is a landmark case, and in fact, it was applied to all the pending cases before the IPAB, etc. Therefore, with this, the council would like to rest the case. Much obliged, Your Ladyship.
1 minute. 1 minute.
Now, Your Ladyships, the first question raised by the opposing counsel was that there of rights in assignment, which is the contract employment. However, Lordships, the fact sheet itself states that the contract employment specifically stipulates that all intellectual or created people on its
Go a little behind.
that intellectual property which has been created by the on the rolls of the university will belong to the university. Hence, if it's a position coming to the remuneration given to the researchers, Your Lordship, the researchers have been working with the university for quite some time. They are one of the most active researchers, and a lot of their patents have been assigned to the university in the place of applicants. Another thing, Your Lordships, they are on the rolls of the university. Secondly, and more importantly, Your Lordships, they've used the money, the time. We know that pharmaceutical research and chemical experiments are not a small matter. So if Mate University is the one which is invested in all the time, money, research in the project, Your Lordships, my opponent counsel talked about it being an atrocity to the true inventor, Your Lordships. Wouldn't it be an atrocity to Mate University that if the compound would not have been invented, the loss would have been there. But now that it has been invented, they're not supposed to get the profits out of it, Your Lordships. That would be all.
Thank you.
There's a lunch break till 2. At 2 sharp, everyone has to assemble here for the valedictory ceremony.